Hi everyone, welcome. I apologize for a lot of parents that tried to reach out the last, week or so because we've been on the road trying to film this documentary film. As you know, we actually got a name for the documentary film now. It's called At All Costs. Um, and so, anyway, I apologize, and we're going to try to catch up with you guys in the next few days. All these inquiries and things. So thank you for being patient, and we also appreciate a lot of our parents who have volunteered to sort of like help with some of the inquiries while we were away. So thank you. Um, I wanted to mention couple of things before we go into this event. Is that please continue to send in the hearts for our Boundless Love heart, Boundless Love art installation. So please mail in. The address is on our website to Los Angeles. The heart cuts out. I'm going to show you some of the more hearts that we received recently. They are beautiful. It's just today I just got back like literally a couple of hours ago. So anyway, please do send them in because we need a lot more. Thank you so much. So today we have the honor of having attorney Jill Scheidt. I apologize, Jill Scheidt. And she is an attorney that actually we reach out to her because we found out the winning track record that she has. And so we reached out to her and she was actually really shocked because she didn't know about our work. So we are very honored that she's here with us to share with us the strategy that she used in her work. So I see a lot of people in the room. If you could please help by sharing this event. We've been traveling, so we didn't actually get a chance to send this out to our mailing list. So we apologize to our mailing list people. If you miss this event, we'll make sure that the recording is going to be available for you to watch later. I apologize. So if you guys could please help share this event. If you don't want to share it in your personal Facebook page, then share it into different groups. I know that you are in a lot of different groups, so please share that so that other parents can attend. And let us know, if you are a parent or if you are a relative or whatever the role you are from, and also where you're calling in from, please, leave it in the comments. And if you have any question for Jill, please do post that, and then we're going to try to address as many as you can. So hi, Jill. Thank you so much for calling in. You are calling in from Pennsylvania. So when it comes to these cases, parents are always advised of keeping records, right? So they always say, document, document, document. Wow, that sounds just overwhelming because it's like, what do I document? How much? It's just too much. There's so much going on. Like, do I document what time the child eats, what the child say? Like, it almost like you're on reality TV. You have to capture everything that's going on between you and your child, and how much of that is going to be relevant when you go to fight this in court. Would you please talk about evidence and records?
Of course, of course. Good to be with you. Yes, I'm calling in from Pennsylvania. I'm only licensed to practice in Pennsylvania, so I can only share what I know here. But I think from an evidence perspective, it's probably similar. Here's the challenge: you don't want to live your life in real time by writing everything down, and we never know at the beginning necessarily if the case is going to need that kind of evidentiary support. Sometimes when people separate or the conflict arises, it's just a symptom of the separation and everything calms down. Other times it's the beginning. So what I tell my clients when I'm first meeting them, or if I take over, I'm frequently lawyer number 2 or 3, because what I find is that a lot of lawyers they don't know what they don't know. So they're not finding it. If it is a conflicted situation, I tell people to keep a custody log, and I tell them to write at the top of it, attorney-client privilege. In Pennsylvania, you're not allowed to take discovery in custody cases unless you ask for a court order permitting discovery. You can, as of right, in a divorce case or a personal injury case, other types of litigation, but in custody and support in PA, the legislature has decided that we're not going to let people take discovery to try to torture each other. So maybe it's not such a big risk, but I do tell them to write attorney-client privilege at the top, that this is created for me, for them and for me, and that might be a work product that would be privileged. And I just have them just do a simple document on your computer, make sure no one's going to see it, You don't want to be accused if your kids stumble on some evidence that you're keeping of you being the alienator, but just put the date, and if something happens that you find peculiar or you believe is detrimental to the children or to you or your relationship, write it down. It doesn't have to be fancy. I tell my clients, do not write me a book. Just put down the date, the time something happened, who said what. Doesn't even have to be complete sentences. And if there is any supporting documentation, if you took a photo of something, if you have a video, and I'll talk about that in a minute because we have a wiretap law here in Pennsylvania that is very, very punitive if you screw that up. And if there's a document, because we might not need that for 2 years. And trying to go back and reconstruct is A, challenging, and B, if you're in a court at some point and you are challenged on the veracity of that, I can have you testify that you were maintaining a log and that you were writing things down contemporaneously as they were happening. So there can be a lot of information. I read these logs and I might not need much that's in there. Then there's a nugget. And that's how you document and you see patterns over time. So again, when you're starting it, you may not realize entirely what's relevant. It is, and some of my clients who are really good at documenting and really good at writing, like my lawyer clients and my other clients who work in the medical field, perhaps, they tend to maybe write too much, spend too much time on it looking for some kind of perfection. But it bullet points, and then I review them when I think the time is appropriate. I do not have every custody client start with a custody log because, like I said, I do meet people who are getting along and we are able to negotiate their cases. But we're talking about cases where we're not quite sure and we never quite know at the beginning if it's alienation, right? Sometimes it doesn't get diagnosed, if you will, until down the road. But I think it's important in conflicted cases. For instance, I have a client come to me and say, Dad always used to call me this bad name in front of the children when we were together, and I think it's continuing, and my children are coming home and telling me, Mommy said you're always mean to her. Why, Daddy, are you always mean to Mommy? And write all that stuff down. Whether or not I can get it in, because we have all these rules of evidence and hearsay, and whether we can get it all in is another story. But experts, at least in Pennsylvania, experts tend to allow us to get objectionable evidence in through them. So it's really important because you may be interviewed a year or 2 or 3 down the road by someone like an expert, a psychologist, asking, what brings you here? Why do you think there's alienation? And then we can pick through. And I actually, in my pleadings and some of the petitions I file, I will quote. I will absolutely quote. So having that written down for me is imperative in these cases. So whatever documents you have that show it, whether it's pediatrician record, where maybe mom calls the pediatrician and tries to have a private conversation to set things up, or a children youth services record, which is what we call it in Pennsylvania, CYS, children youth services, or a police report. So whatever you have in the most organized fashion, but concise, is what I'm looking for. Does that answer the question, Dr. Deeter?
Yeah. Thank you so much. And actually, Samantha Smith in the chat room mentioned, I think, exactly what you just kind of touched on a little bit. She said that I have audio recordings, and I think you mentioned about the wiretapping law we're going to discuss soon. So it doesn't mean that you can actually be in trouble for that. So let's talk about that in a bit. And then she said, I have text messages from my alienated teen daughters and her friends about discussion with her dad, things like that. So she doesn't know how to get the evidence in, and you kind of touch a little bit on that about, having expert witnesses. But what I got so far is that you seem to say that they should be keeping records on a chronological order, right? So today this, and then the next day something else, but try to keep it somewhat consistently, right?
Yeah.
Okay, and then she said, and then something else that you mentioned about, it's so interesting, you said, like, a lot of the time, the parents, by the time they come to us, we found that at the beginning, a lot of the time, parents don't realize that in this situation. All the parents that actually we found that came to us, by the time that they recognize the fact that we are here, is they already deep into it, and they don't have any of the past records. So I think the fact that you mentioned that You don't have to start right at the beginning, but as soon as you realize or you suspect that something could be, because a lot of the parents just think, am I being paranoid? Like he always, says this and that to the kids. He said to the kids that, oh, you don't care about them, you don't love them, or, this and that, or you just feel like, well, am I being paranoid? Like, should I take note on that? It's a lot of the time parents just let it pass until it became so serious, and the children turn away from them. So it's kind of late by then. So I think that's a very good point, because like Samantha said, she looked back 3 years, and then finally she see the patterns of the behavior. And then, Sasha also added that get a recorder app for your phone that records every ongoing and outgoing call. So let's talk about that wiretap law, because again, Sasha mentioned something that also related to what Samantha talking about, audio recordings. Would you talk a bit more about that?
Sure. The question, before I talk about the wiretap law, the question about how do you get it in? Sometimes it's gold when you find communication between your child and a third party, either a peer or the other parent. And authenticating that, and again, I know I already talked to you, Dr. Deeter, about the volume of information you want us to cover in an hour, but authenticating, getting evidence into the record over objection, that's tricky. And that's another conversation. But I say, if you own the phone, if the phone's on your bill, hopefully it is, and take screenshots. I know there are apps out there. I just had a client use an app called Textra, because when you take a screenshot of a text, it's really annoying to print that out and then create the paper. We're not high tech here in Berks. We don't have a high tech courtroom. I'm still printing off paper and making 4 copies of everything. It's maddening. But the screenshots, when you print them, they're not meant for that. So there's an app. It's called Textra. I just learned about it a few weeks ago, and my client generated a document, and it almost read like emails to and from all the texts between he and his wife. When you're talking about third-party texts, and that's what the kids are, they're not parties to the case, even though that's why we're here. Getting that in is another conversation, but I think you should gather it. So yeah, wiretap, Pennsylvania wiretap law.
Oh, sorry, hold on before we go on to that. So you're talking about getting screenshot or getting record of the conversation that is on a phone that you have access to. So what about cases where you know that, for example, your children have conversation with other people, but it's on a phone that does not belong to you? Let's say a phone that belongs to the other parent. Or can you actually subpoena for that record?
So in Pennsylvania, what you would do is you would have to go to court and ask the judge for permission to engage in discovery and ask for that to be produced, and either have your own IT person dump that or do whatever it is you wanted to do. For instance, if you wanted medical records or school records and the custodian of those records was not allowing you to do it, if you wanted to just get that information so you could look at it, you would have to go to the trial judge and say, here's what I want and here's why. I need an order permitting me to engage in discovery. And then I could serve a subpoena and ask for that information to be given to me. If I'm serving a subpoena, to attend and testify at an upcoming hearing, I don't need leave of court to do that, but I don't have the advantage of looking at it and analyzing it in advance. So you must put the cart before the horse here and get the information to see if it actually exists, and the alienator and his lawyer are going to object. So yes, gathering evidence from sources is tricky, because A, you have to know it exists, and B, you have to get it and hope that it hasn't been wiped clean. And if your kid's already alienated from you, he or she might delete everything. And these kids they're communicating on Snapchat and other apps where the record may be gone. The whole point of it is that it's gone. So this is very difficult with this current technology that we have. Then when you get it and you analyze it, and you may have a judge that says, no, because I think this is unnecessary. You're creating a sideshow here. No, this isn't. You're just making this up. The accusation that the alienated parent has actually alienated him or herself. So you have to analyze what you want, and then you have to permission to do it. And a lot of lawyers in Pennsylvania aren't even aware that you can't just serve a subpoena and get documents like you can in a personal injury case in PA. Regular civil case, I can, once the action is filed and I have a docket number, I can engage in whatever discovery I want. If I want to bring somebody in here and sit them at my conference room table and ask questions, I can. Not in custody without court permission. So that's a tricky. That's tricky. How do you get that information? And I have a case right now where mom owns the phone. Mom is finding all kinds of images and stuff that's going on in dad's house, and it is so helpful. And we're trying to authenticate it without having to bring the child in to say, is this your phone? Are you the one who sent these texts and these photos? Because that's the other issue, right? So like most of these custody cases, kids sometimes, unfortunately, are absolutely necessary to authenticate that evidence. Yeah. So the more you can gather that's legal, yeah, the better, so that we know what we have to ask for and that we have reason, that we can justify the ask. Okay?
So
does that answer the question?
So what about, you mentioned about, like, they could, let's say, talking about text messages, and you said they might be deleting it already. Can't you subpoena to the phone service provider for the record?
If you get leave of court to do that, I don't know that carriers maintain texts.
Oh,
like we all know emails live on servers somewhere. Like yes. If I send you the emails you and I have exchanged, yeah, all live on my server. So if we think that dad is emailing child, yeah, from a work computer, but then he's deleted it, we could serve some discovery, right? But I don't know that carriers are maintaining the
yeah, so we have
some of them do.
Yes, yeah, we have a case right now. Like for our documentary film, it's in Colorado, and we found that actually Sprint in Colorado, anyways, they do keep text messages record. But the same, like you said, we have to actually go to court and get subpoena for that. Otherwise, we won't get the access, unfortunately. So yeah, thank you.
And then when you do get it, you have to prove, if you find something in there that's really damning and helps you, you have to prove, and the court has to accept that we know it's from this phone number to that phone number. But who sent it? I mean, is it likely that someone's taking my phone and texting my children? Probably not, right? But there's still the evidentiary issue of what do we do with that mountain of evidence, right?
Right. Thank you. Let's just check a few things. I think someone said, Selma said, how do you spell that app? I think it's Textra. Is that right? Textra?
Textra, that's right.
Yeah.
I have not personally used it. I asked my client because he told me, I have a custody trial scheduled for Monday, and he told me about the text messages, and I said, because of that screenshot issue, I said, is there any app you can use? And I mean, I'm not taking somebody's phone and doing that. I don't know how. I don't feel comfortable. I don't want to be I can't be a witness in a case. I don't want to be accused of altering any kind of text. Yeah. And he figured it out on his own. And he said, and now he's being accused of altering stuff, which we'll deal with that on Monday. But it reads very, very well. It reads just like an email string, to from.
I see. Okay, thank you. So let's go into the wiretapping discussion.
Yes, the wiretap law, right.
Yes.
So Pennsylvania has a wiretap law. I understand occasionally there'll be a high-profile case where somebody gets in trouble in other states, that other states have them in some form or the other. And it's an old law where they're talking about literally tapping a landline. Where they're actually, you know what I'm talking about, Dr. Deeter.
Yes,
it's the language. I mean, the legislature is so far behind in all technology. It takes years. But in Pennsylvania, we are what I call a two-party consent state. So if I call you and I record you without telling you, it's a felony. I am violating the law. And and it's really tricky because all these phones now have both video and audio, and that didn't used to be the case. If I wanted to record someone, say a staff member surreptitiously, I used to have to use a little micro cassette, but I have to give consent. Now there are exceptions, but that's where we start. And I have clients who come to me and say, I recorded my ex last night in the house, and I want you to listen to it. And it's actually also a felony for me to listen to it, even though I didn't record it. Now, I don't know that anyone's ever been prosecuted for the latter, but the former, absolutely. Wow. So you have to get consent. So if you now here are some exceptions. If I'm leaving a voicemail, I know that's being recorded. So that's not an issue here. But if you're recording your child in your home, or you're recording another adult in your home, and they're unaware of it, and this is why when you call, say customer service, you get that this call may be recorded for customer service. That's why they're telling you that. It's really not to be nice, and I don't really know that they are recording it for customer service, but whatever. So we in Pennsylvania, that's a big risk. And I have had clients, and a lot of lawyers don't understand this. I have had clients mount a little phone camera, a recording device to record the exchange surreptitiously, and then the lawyers are like, aha, I'm going to move for evidence. I'm like, that's a felony, and you got to be careful. Oh, yeah. And that's why you'll see signs that say, you may be recorded here. Now, there are exceptions. If there's no expectation of privacy, I think in schools, kids don't have the same, and there's a difference between video and audio. It's the audio recording. That's the issue. It's not the video recording in Pennsylvania. So again, I can't give it any legal advice, and I only practice in Pennsylvania. But be very careful if you are recording your children or you are recording your ex. And I do have clients who, during exchanges, they're like, I'm recording this, and I have seen occasionally people get arrested for doing that. So we have to tread lightly, and we have this capacity. I have 2 devices in front of me right now that I can audio and video record on at any given moment for free. It didn't used to be like that. But the wiretap law is an interesting overlay here, and it not only can you get in trouble, there are ways we can use it to our advantage too. You can get surveillance tape if if something's happening. Like for instance, high conflict cases, you might be exchanging at a designated spot at a police department where they have it set up that there's always video. You're being recorded then. But I'm talking about when people are calling me up and saying, I know that my children are always saying that mom is saying X, Y, and Z about me. So I sat them down and asked them questions and recorded them. Like, I don't know that I can use it. Maybe I can, but maybe I can't. So that's one of those. Be careful. You don't know what you don't know. And depending on what state you're in, it may not matter. I understand in Ohio, it's a one-party consent state, which doesn't really make any sense to me, because if one of you is recording, isn't one of you giving consent? Yeah. So I think in certain states, record away. Yeah. But here in PA, we have to be really careful.
Right. So I think so. So Pennsylvania, to summarize it, you're saying that in Pennsylvania, it is a 2-party consent, meaning both sides have to consent for the recording to be. And we are only talking about the audio side. With video, you can film it without any consent. Is that right?
So with video, which is how people mount video cameras, and that's my understanding. It's just the audio.
Okay, so for parents, I know that you guys are calling in from all different states. So this is something to definitely look out for. If your state is a 1-party consent or a 2-party consent state. So for example, we know that in Colorado, it's actually a 1-party consent. That means that if you are having a conversation with another person, if you consented, you can record that conversation. I'm not a lawyer, so this is not a legal advice, but I'm just sharing what I think or what I found with other people. So Sasha mentioned about getting an app to record the phone conversation. Be careful with that because it depends on your state. Okay, so we talked about wiretap law. So let's continue. Was there any other things that we were about to mention and then we forgot? I forgot.
Let me give it a little more specificity with what I like to see in the log.
Yes, please.
Obviously, dates, times, who, what, where, and when.
Yes.
So if there was a witness, a name, a phone number, I know nobody wants to be called into a custody trial if they've witnessed something. But what I find is that when we're evaluating what evidence to use, and we're telling our recollection of what happened. The other side may weave something else into it. So the more accurate we can be, and having a disinterested third-party witness come in, who, again, disinterested, doesn't have a horse in the race. It isn't coming from mom or dad or maternal grandmother, right, or step-parent. We've got a disinterested third party who happened to witness an exchange. That kind of witness can be very powerful. So if you have a third party, someone who may have witnessed something, a stranger or a friend, or say a parent of one of your friends' children's friends, that's it. You write down the name, the phone number, because we may need to call that witness. Again, it may be 6 months. It may be, I'm having a trial next month and we're bringing witnesses in for something that happened last summer. It could have happened the summer before that. So we need to be able to find those people, and can't count on them to be happy about it at all. So that's what I like. I want to know who, how we can get in touch with that person, whatever was said, quote it as specifically as you can remember. Okay.
Could we address that a little bit more? Because I think sometimes parents feel like if the witnesses write a letter, that would be good enough, but it's not at all, right? Because they cannot be cross-examined. So could you just address that a little bit? Because
Sure. I like the statements. I like for a couple of reasons. One is when you write it down today or tomorrow after something happened, your memory's going to be better. And again, if you get challenged on your memory of the event, you can say, well, I don't really remember it as I sit here today, but I can ask if looking at your statement that you wrote contemporaneously with your witnessing the event, would that refresh your recollection? It's going to be pretty powerful as pretty accurate, because it's made, and we have business exception records to the hearsay. It's hearsay. Let me start with that. Hearsay is an out-of-court statement offered for the truth of the matter asserted. And that's what that is. If you have somebody write down a statement, or a police officer shows up and takes statements from people, it can be double hearsay in the same document, right? You can have multiple people, I'm writing down what somebody told me, I didn't witness it, that's double hearsay. So having the statement is helpful, but it is not a substitution, except in certain cases, of having that person come in. Because there are constitutional rights that are afforded litigants, not just in criminal defense matters, but in civil matters. You have the opportunity to confront the witnesses against you and the evidence against you, and you can't confront the written document. So, unfortunately, and in child custody matters, I think it's the worst, because I've tried civil matters, I've tried homicide cases, I've tried personal injury cases, custody cases. It's the worst, because people don't want to be involved. They feel like they're being chosen to pick sides, and sometimes the witnesses are the children. So you can't just give the judge an affidavit or a statement. You need to present that evidence, and usually it's through the person. So that's why I need names and addresses, because if I need to hunt somebody down, if somebody witnessed something at, for instance, the case I'm trying next month, there was a big ordeal at the child's soccer game. So we have, unfortunately, somebody who coaches these children is going to have to come in and say, Dad did this, and Mom was here, and he's kind of the best evidence, if you will, having that person come in, and this is what that person overheard. Very reliable. Again, the third-party disinterested witnesses tend to have more credibility than a parent or a relative. So we have, just because the case is about children doesn't give us a free pass. We are bound by the rules of evidence. And look, I get it. I try cases in front of a lot of different judges. Some of them don't enforce the rules of evidence, but they're supposed to. It's one of the things that drives me nuts. We don't just let everything in because it's in the best interest of the children. The rules of evidence and civil procedure are supposed to be enforced in child custody litigation. So, and you want that too. You don't want your ex coming in and bringing in a bunch of written documents and then you're trying it that way. So we have to authenticate. We must respect the hearsay rules. I know, I only know Pennsylvania rules of evidence, but I also, in law school, and I have some federal cases, there are federal rules of evidence. Hearsay is a pretty ubiquitous, and And that amendment, or excuse me, it's one of the amendments. You have the right to confront your witnesses. And due process, again, another constitutional concept. Your rights as parents are very, very well protected. And what I find is that, the rules matter at trial, but when we're talking about criminal defendants and parents who may be losing custodial rights of their kids, very, very protected. So we have to respect those rules of evidence.
It doesn't feel that way. A lot of parents doesn't feel like their rights are carefully protected, actually. But yeah, I understand what you're saying. Yeah, it's funny because a lot of the time, I mean, it's not funny. It's unfortunate. A lot of the time, parents gone through just in and out of courts for so many years because of all these false allegations and everything. It's crazy. But I'm sorry for interrupting. You said you have a few different things that you want to address. Go ahead. Is there any more in your list in terms of what you wanted to see in the records?
So we can roll into I think we were going to talk next about how do you defend yourself or use that horrible accusation that's false as an opportunity to create evidence against your ex.
Yes, please,
I don't want to spin it and tell you that you should be happy that any of this happens, but alienators have several tactics, and one of them is to paint the alienated parent as the high risk bad parent, and accuse that parent of driving drunk, of physical abuse, of inappropriate discipline, of neglect, and I know in my high conflict cases, I get those phone calls at night and on weekends. I'm defending them when they're being asked to give an interview to a police officer. I am going to court with them because they have a PFA against them, protection from abuse, and it's difficult. I don't have an easy answer. There are times. So what my answer is, if I'm involved, I need to know. I need to know, and I've done a fair amount of criminal defense, so I have no qualms with calling up these cops and saying, you need to call me back. I don't care what time it is, and I will. Most of them will talk to me, and they don't want to be involved because they're savvy and they know a lot of this is custody BS. Okay, and so are our judges locally with the PFAs. A lot of them look at this with a jaundiced eye, and I want to be there when my clients are being interviewed, because things can get twisted around, and I decide whether my client's going to give a statement or not. Sometimes the cops just hear from me and they're like, yeah, I'm closing the file. There's nothing here. And then I get the police report, and then I keep that in with the rest of it. And if the opposing party does it enough, it will show a pattern of the further alienation. So it's important that, of course, you cooperate with Children and Youth Services. And I can't always be there. They show up pretty fast if there's an allegation, or they want to do a welfare check, if a cop wants to do a welfare check. So, yes, it's going to happen with the alienating parent, and you need to have your wits about you, and you need to expect it. Because what happens is when the alienating parent doesn't get what he or she wants through his lawyer or the courts, they go the other way because it's free. And it's fast. And so you do need to keep track of all that stuff, because what they're going to do is they're going to spin one of the facts that happened and what the kids said to them. Now, you may end up getting CYS involved because your kids have said something to a mandatory reporter, a school nurse, a school teacher, right?
Yeah.
And my position is, if I have a client who hasn't done anything wrong, we're going to talk. But I want to be there because people treat unrepresented people very differently.
Right.
I know you're a filmmaker. You watched Making a Murderer, right?
No, but yeah.
It was on. If you haven't watched
that,
wow.
but I understand though. I do understand because definitely. So what you are saying is that if your client, so if someone is the police turn up and wanted to ask you a question, it's best if you have a lawyer is to ask your lawyer to be there before you talk to them, right? That way you can protect your rights. Yeah. Absolutely.
And I'll tell you what I tell my young adult children. If the police want to talk to you, you tell them, not till my mom gets here, handcuff me to this table. I don't care. I'm not talking to you. Now, in reality, sometimes the police have already been in and out before I find out about it. And they recognize, and we have our DA of this county, used to be in private practice like me. He's not like some career politician, and he understands that these high conflict custody cases have a lot of, he doesn't want to get involved. So he has instructions through all the police departments in the county. Don't get involved in this stuff. We're not enforcing custody orders. That's not our job. That's a civil matter. But so a lot of the police in this community are very, very wise. But absolutely, do not make an appointment to sit down with a cop. Do not submit to an interview with Children and Youth Services if you can avoid it, unless you have your lawyer in tow.
Yeah, I somehow I felt like with children's services, it could be like a misunderstanding, but somehow I misperception. But I felt like if you say, "Oh, I want to get my lawyer first before I talk to you," it seemed like they think that, "Oh, you must be guilty or something." Do they actually respect, or do they make it worse when you appear with regard to children's services? I'm not talking about police and that, but
So I know that it makes their job more difficult, because then they have to schedule. What they do is they show up very, very quickly. So if there's an allegation that they get, say, through the school, they might show up at your house if you're the custodial parent within 24 or 48 hours.
Right.
And they want to see the child. They want to lay eyes on the child. But for an interview, I don't find that they automatically assume that because you have a lawyer, you're guilty. If it's an ongoing custody case, and you believe you're being falsely accused, I think it's fair for you to tell them, and for me to tell them, look, you probably have no idea, but we've been down this road for 3 years. This guy keeps doing this repetitively, and here's how he's doing it. He filed bogus PFAs, and I find that some of them are very sympathetic to the alienated parents. And they take a look at the dockets, and I ask them, what do you want to see? We had a trial on this and he lost, and he's still doing it. And they're open to that. Are there people who assume that you're guilty because you got a defense lawyer? Maybe. I'm okay with that. That's still my policy.
Yeah, thank you. Okay, yeah, please continue. I know that we have a few things that we want to cover, so go ahead.
I know, we have a lot we want to cover today.
And actually, to everyone, before we have this talk, Jill and I had this conversation about how all the things that I wanted to cover for you guys, because I know you have so many questions, and she, like, really, we look at all this topic, and we're like, there's no way we can cover all this in an hour. So thank you so much for trying to, like, really condense this down. But yeah, go ahead, please. Yeah.
So one of the list that you gave me, one of the things that you brought up was when do you file what? What do you file and when, right?
Right.
And so again, this is very state specific. Pennsylvania this is all statutory. It all lives in these books that are behind me right here. We have a domestic relations code that covers divorce, support, custody, adoption, abuse, all of that stuff lives in the code, and some of it lives in the rules of civil procedure. So what do we file and when and what happens? We have here the option, of course, you file an original custody complaint when you need an order to be established. A lot of this alienation stuff happens even after that order has been established or while it's happening, but you may have a temporary order in place. So what happens if you have a parent who's acting up, you think is engaging in alienation? I'm always looking for that. I'm always looking for maybe symptoms of a personality disorder. I'm looking for symptoms of drug and alcohol use. Quite frankly, give me an alcoholic any day over an alienator, because they're easier to deal with. So what do you do? When do you file and when do you wait? And what do you file? So each one of these options that I have in my toolbox in PA, they're different. So asking for an actual trial, that's the original custody complaint, or if you have an order in place and you want to modify that, you file a petition to modify. That triggers the trial. At trial, you're asking the judge to either change the order that's in place or create one. And we have in Pennsylvania a codified list of factors. The trial court must evaluate and analyze 15 factors, and then there's a 16th catch-all. And one of them is alienation, but the legislature refused to use the word. it is attempts of one parent to turn their child against the other parent. I call it the alienation factor. It's number 8, but they don't want to use that word because that is a loaded word. And I can tell you, I try to stay away from that word at the beginning because some people think the judges don't like it, they don't believe in it, or they think it's too dramatic, or they think whatever. So that's what you do when you want to change an order. You can also ask for contempt, which is a willful violation of an order that's already in place. Or you can ask for special relief, which is a catch-all that you're asking the court to do something. Order an evaluation. Order counseling for a child. Require the parents to use a parenting app because communication is so terrible. And maybe all the communication is going between the kids. And you're just like, we're not doing this anymore. You can't put the kids in the middle anymore. So special relief is a variety. And each one of these has its own list of what you can and can't do. For instance, I have a case right now. They have 50-50, teenage daughter. And dad refers to the child, I represent mom, as when he talks to her, calls mother, your effing mother. Okay, that's what he calls the mother. It's a new case to me, and we looked at it and said, well, this child wants to live with dad. We think that dad is making life easy for her. She can sleep in, she's failing classes when she's at dad's house. Okay, so if you file a petition to modify the schedule, it opens the door. Dad can then say, oh, you want primary? No, I want primary. So I didn't file modification in that case. I filed contempt because I want the judge to tell him, you're not supposed to call your kid that, and the judge can't modify on contempt. So the judge did find him in contempt. She did believe that because he got mad at me on the stand. It was really interesting. And I asked for some special relief in that petition. So I did a hybrid of those two. So I need to know what's going on, and then I need to decide what to do and what not to do, because you need to have a plan when you go to a courtroom, and a lot of lawyers don't have a plan. They just file something and hope that the judge figures it out. Bad idea. Very bad idea. Because these judges, some of them know nothing about family law. In Pennsylvania, all you have to do is be a lawyer, you get elected, and I'm in front of judges all the time who say to me, you know way more than I do. Let me, and they're very humble, a lot of them, yeah. But a lot of them aren't. So you have to be careful what you ask for because you may regret it. So knowing what you can get, and under the contempt statute, like I said, you can't get modification. You can't get makeup time under the Pennsylvania contempt statute. So if dad kept the kids from you and you lost Christmas or half of Christmas or whatever you were supposed to get in violation of that order and you file for contempt, Pennsylvania, there are 5 limited remedies you can get: a finding of contempt, attorney's fees, a fine. You can be put on probation. You can have your driver's license taken. Again, I don't understand why the legislature did that, but you can't get makeup time. There's pending legislation in PA to do that, and I don't think that passed yet. If it did, I apologize. I don't have my finger on the pulse of that one, but we're trying to get the legislature to change that, because shouldn't you be able to get makeup time? So you have to file special relief if you want makeup time.
Oh, I see.
So the answer, I mean, you don't need to know all these specifics about PA, but the takeaway is, the practice pointer is, what are you looking for? Will it make things worse? Will it require you to bring your kid in to testify who's already mad at you? Maybe not for good reason, but how are you going to prove your case? What are you asking for? And can the judge accomplish it? Because I hear judges say this all the time. Look, if you do that again, I'm going to take custody away from you. I'm like, I get it, Your Honor, but you don't have jurisdiction to do that. There's no pending petition to modify in front of you. And they get smacked. The Superior Court will reverse a case and say to a judge, basically, I know why you did it, but you didn't have authority to do it. So we have to be mindful of what you can and can't get. And I get it. People come into me all the time and say, he's violating this order over and over and over again. And a lot of our judges will not hold parties in contempt. And I disagree with it. And I tell them that because I give seminars here. And as you can see, I'm free to speak my mind. And I will tell these judges, you need to find people in contempt. Otherwise, clients ask me, well, what's the point of an order? Right. So you also have to know your audience. And if it's a judge who won't hold people in contempt, I tell my clients, I don't want you to spend the money or the political capital on it. Because you have to be careful about the judge's perception of you and me. And it's not that I'm afraid to do it, but if I know it's not going to get anywhere, I don't want to get your hopes up. And it's very individual. Okay, in my county, I'm 60 miles northwest of Philadelphia, much, much smaller than Philadelphia. We only have 13 judges, and 4 of them are assigned to family court. I know them all. I know all the support and custody masters. I know the divorce masters, and they're very different from one another.
So
some of them like 19, what I call, what's that?
Can you file for a change of judge if you knew that he or she weren't, is there a way for you to, no?
So you can ask a judge to recuse him or herself if there is a conflict, such as one of my partners is running for judge right now. I anticipate that he's going to get elected, and when he does, there are going to be people in this community who say, I don't think Jill should ever appear in front of him because they were partners. But you're not going to get a new judge because you think the judge doesn't like you. And quite frankly, judges do form very strong opinions about parents who come in front of them. That's not going to be a basis to get a recusal. It has to be really, really egregious. And so if you've had a trial in front of a judge and you've lost, you're if it's an assigned judge system, and that's what ours is. They're not all, but that's what ours is here. We actually have a one judge, one family policy, so that if you have a divorce, custody, PFA, you're going to get assigned to that same judge. We didn't always have that. So you're not going to get a new judge. I hear that. That's a fair question. Around here, you'd have to prove that someone treated someone basically unethically. It can't just be that he ruled against me.
Yeah, thank you. Okay, I just want to mention there's so many questions and I'm not able to catch everyone, but William, I really wanted to be able to pick your question, but I don't actually understand your question because it's broken up into multiple pieces. So if you wanted to rewrite that would be great. I know Rachel had a few questions about, why is it that some judges, and actually not just Rachel, I think someone else too, what if a judge doesn't follow these rules? And I think you kind of touched on this a little bit, Jill, where you said that, you actually make the judge see that they have to hold a certain standard, right, with these rules or factors that they have to consider. So could you address a bit more about this? What if the judge just takes the other parent's story and not follow, for example, the evidence rule or something like that? How do you get the judge to,
Yeah, this is complex. The first thing that needs to happen is your lawyer needs to know, and a lot of family lawyers are good litigators, but a lot aren't. You need to make sure you create your record. And what I find is that if you see that a court reporter isn't taking things down, if you see that the judge is just kind of freewheeling from the bench and talking about stuff and treating it like a conference, I need to be firm and say, Your Honor, I want testimony. And if even when the judges push back and say, I don't think we need to have a hearing, Your Honor, I need to create a record. I want to call a witness. I understand you don't agree with me. I need to create a record. I need to put this, because if you don't have a record and you file an appeal, it didn't happen. Okay? It didn't happen. Now, sometimes mistakes are made. For instance, I recently covered a case where the parties were litigating the postnuptial agreement and the validity of the postnuptial agreement, and everybody was talking about the agreement. Nobody moved for its admission into evidence, which is a technical, we all know we're talking about it. It was marked as an exhibit, but it technically wasn't moved into evidence. So it wasn't part of the record when it went up on appeal. If that happens in your custody case and you appeal it, it didn't happen. So what you need to do is you need to make sure when you're at a record hearing that everything's done correctly, even if the judge doesn't want to hear it. And then afterwards, and you need to preserve the issues. So if I make a hearsay objection and the judge lets something in or doesn't let me put something in, it's no different than a criminal case or a jury trial. It's no different. You're creating a record. You can complain on appeal that the trial judge was wrong, was incorrect, didn't properly apply the laws or the rules, okay? Here's an issue, though, in custody that's it's more common in custody than anything else. Interim orders in Pennsylvania are not appealable. You can only appeal the final order. And a lot of these special relief and contempt can be considered interim because that ultimate petition to modify hasn't been resolved. So when you have a situation where you think a judge, and I've been in this boat, has made a knee-jerk reaction and didn't properly consider something, you can file a petition for reconsideration and say, Your Honor, but then you're back in front of the same judge and say, I think this was a mistake. You need to find a lawyer who knows how to try a case and a lot of family lawyers, I find this interesting, are avoidant of litigation.
Yeah.
I think we litigate more in family court and criminal court than the civil litigators who say, you see the commercials, we do the car accidents, we're litigators. We're in court more than they are. And I used to do that work, so I understand it. And I need to know the rules of civil procedure, the rules of evidence. I need to know how to create the record, how to deal with objections, how to tell the judge, I need a decision on this. And that's how you protect yourself. But it's an imperfect process.
Yeah. Actually,
it's imperfect.
You just mentioned something really, really important. Is a lot of the time, the lawyers will just negotiate with each other and then tell the parents, "Oh, you should just, you should just settle, or And they avoid, like you said, they avoid the trial. And because you don't have a trial, you don't get a fair chance of getting all of your evidence and your witnesses, and you never get to be heard properly. And then you can't hold them accountable for the specific procedure that they had to follow, right?
And then you don't have a finding. So in these alienation cases, or where a high conflict case where one party, maybe it's mental health, whatever it is, some of the time I tell my clients, we need to finish because we want that decision from the judge that says, because when there's an analysis, in a custody case in Pennsylvania, I don't get a one-paragraph order. I get the whole analysis. Here are the findings of fact that were proven at trial, and here, factor 1. This factor favors mother or father, or it's not applicable, or it's neutral. And then you get those findings. But again, I am continually surprised at how many lawyers do not protect the record. They do not move for the admission. They don't have their exhibits in good order. They don't understand the objections that are coming in. They don't ask for stipulations. And then the record's a mess. The judges are, they're burnt out. From if you've got a judge on the bench for any period of time who is just hearing, because they don't hear the easy cases. We settle the easy ones. They're only hearing the high conflict cases. So they're strong arming us to settle. You're right. They're strong arming. Like, I tried it, Judge. I had that conversation with my client for the last 2 years. You need to make a decision. So you need to find a lawyer who is willing to put the time in, because trial prep is really time consuming. I need to make sure I anticipate all the evidence that's coming in, any possible objection I have, and I have to defend those objections. So, but again, if it's not in the record, you can't complain about it later. And who wants to file an appeal? That process. We have a children's fast track system. I know not every state has this, but Pennsylvania does, that when it's a child custody case, it's almost like a right to a speedy trial.
Right.
And it's supposed to get decided within 180 days. Well, that never happens, especially if you have to have an expert involved. That's 6 months. But same thing on appeal. They're supposed to decide them faster on appeal. But again, the Superior Court of Pennsylvania, they call themselves an errors and omissions court. It's not a do-over. It's our burden to show them that the trial court screwed up.
Yeah. So you
have to preserve your record. You have to make objections if you don't want the evidence to come in, because if it comes in, you've waived the issue. Okay. Another question.
Yeah. Actually, I just mentioned in the chat room there's Jing. And actually, because of her case that, or partly because of her case that actually in Colorado now we also had that. Well, I'm not from Colorado, but I mean in Colorado now there's also speedy trial. Like you mentioned with Pennsylvania. Mm-hmm. But I wanted to bring up this particular question. So William said the judge signed an order that doesn't represent what he ruled in the courtroom. We got the hearing transcripts and filed a reconsideration to the same judge, and he dismissed our reconsideration. Now they said that I'm past the appeal period. Now we are going to trial for the final custody order, and they said that I can't use a transcript because a written ruling supersedes an oral ruling. So what's your advice for him? And this is in Washington State, so it's different. But like, what would you see? Yeah,
I would make sure to preserve that on appeal. That I would have my objection, have my attempt. If there was something I wanted to make part of the record, I would have my attempt to do so on the record. I would put it in my pretrial submissions, because most people have to submit proposed findings of fact, conclusions of law, and I would be prepared to argue. The good news about custody cases is they're non-jury, so you're talking to the judge, but you need to preserve it. So mark that transcript as an exhibit and tell the court you want it to be made part of the record and let the judge make a decision on it. I also defer to your counsel in Washington State because I don't know that that's the right answer because I don't have a license out there. But if it were here, I would, that's what I would do. And I would make the same objection or attempt to introduce that same fact at trial.
Yeah, I think the challenge he's saying is that he passed the appeal period. So now he got going to the next trial, but they said and they said that he can't use the transcript because the judge wrote a written order. So they said that the written ruling supersedes the oral ruling, which is the transcript.
Right.
So
yeah. He could still try and
so still
maybe
try pushing the transcript in. Yeah.
You can still try, but it may not get in. But if you wanted to appeal the new, I understood the fact pattern to be that.
Yeah.
So if you wanted to appeal the new order that's going to be entered, you could raise that.
I understand.
Maybe.
All right. So yeah. So now you're going to the next trial. You're going to try to push the transcript onto the record to be included on the record, and then you can, if it doesn't work, then you can try to appeal now because now you have a new trial coming up. Right.
Right. To me, it's no different than anything else you're trying to preserve for the appeal. You're trying to create the record and state what you're doing and why you're doing it, and then let the judge make the ruling. It's no different than me trying to get something in, and the judge, objection, it's hearsay, and I say I don't think it's hearsay for X, Y, and Z, and then the judge makes the decision, and then I lose, and I say if I had that in, I would have. That would have been a different outcome, and the judge erred in denying the admission of that. Yeah, I think that's how I would handle that.
Okay, thank you. There's a few questions in the room about how to hold the judge accountable. We talk about appeal, but other than that, I think there's also discussion about the judge has the immunity. So is there anything that parents can do if they felt like they were unfairly treated? Is there something unethical going on by the judge ruling? How do they hold the judge accountable?
So, unethical behavior, I've personally not seen any that I would. I think the trial judges take this work very seriously. Unethical behavior would be perhaps doing his or her own investigation, no different than a juror isn't allowed to do that, or having perhaps ex parte conversation about the substance of a case, or having a personal relationship with a party or witness and not disclosing it. And it's no different than any other case, that if there is unethical behavior by a judge, there is a judicial conduct board in Pennsylvania, and we are obligated to report that behavior. I think it's rare. I think that because I meet people who've lost custody trials, and I don't win every trial. I don't win every hearing. And a loss is different than, and the judge not believing. If the judge doesn't believe that there's alienation, or more likely, if the judge believes there is alienation, but doesn't give us what we're asking for as the remedy, that's what's so tough about alienation, is what's the right remedy. And it's not always, people think if they can prove alienation, they win. But what's a win in child custody? And it's rare, but there's a process in place. Judges do get reported. They get reported a lot. Yeah. Counselors get reported a lot by the party who perceives he or she has lost. So if you think there's unethical behavior, by all means, there are judges who get caught taking bribes. I don't know any who have, but I've read about it.
Right. So so essentially, if you wanted, there's few options. One is to try to appeal your case to get the decision reversed. Two is to file for appeal. File a complaint to the board if you truly believe that there's something unethical going on. But you can't really sue the judge. Is that correct? Right. Okay. Thank you. So we are actually running. We ran out of time. Thank you so much, everyone. And I apologize as always with these events. There's so many questions and we can't cover all of this. I do want to say that if you are coming from Colorado, I wanted to hear from you. Could you please message us on VictimToHero Facebook page or website, we have some particular things that are going on with the legislation situation. So we want your support. You can help making some changes. So please message us if you are coming from Colorado. And then there's a question about perjury. We're going to try to get some DA office to talk to us about perjury. So we won't address that today. We really don't have enough time. But thank you so much, everyone. Please share this because the recording is going to stay with the event. So share it for other people. And thank you so much, Jill, for being here. Really appreciate you. Thank you.
Thank you for the opportunity. Bye.